everyone, welcome back to the channel. My name is Varun Kaushal and I am a legal intern at LEXIS and Company. Today I am going to discuss about freedom of press and court of proceedings. Before a court passes a judgment during hearing, many things happens. Heated argument between the lawyers, remarks by honorable judges, whether soft or harsh, are part and parcel of court hearing. There has been recent trend in media to report what transpires in a court. We read judgments pronounced by the honorable judges and court orders on daily basis. These days, legal journalism has also seen rise as there are many legal platforms has been emerged. Court proceedings are getting reported on daily basis. Besides political and social news, legal news are also occupying substantial space in newspaper. Media has been considered as fourth pillar of democracy. Post-independence India, media has played crucial role in keeping the fabrics of democracy intact. Balance between legislative, executive and judiciary is as much sine qua non for democracy as freedom of press. Indian Constitution has been framed in such a way by the makers of Indian Constitution so that neither of the pillar can go astray. Often it has been seen that whenever judiciary or executive try to overreach its domain, it is always checked by media. Media plays the role of a mirror in which image of country and system prevailing therein is reflected as it is. Idea is to keep the mirror intake and clear. For keeping democracy alive, freedom of media is must. But to what extent is the issue? The issue has cropped up again in view of recent oral remark made by Division Bench of the High Court, comprising of Justice Sanjeev Banerjee, Chief Justice of the Madras High Court, and the Justice Senthil Kumar Ramamurthy on 26 April 2021 against the Election Commission. The Honorable Division Bench, Madras High Court, while dealing with issue pertaining to widespread of second wave of COVID pandemic in India, orally observed that the EC, that is Election Commission, is the institution that is singularly responsible for the second wave of COVID-19 and the Election Commission should be put up for murder charges. Though this oral observation made by the Honorable Division Bench, Madras High Court, was not forming part of any judicial order or judicial record, however, this oral observation has widely been reported in media. Based on the reporting of this oral remark in print media, on 27 April 2021, an individual filed a complaint against Mr. Sudeep Jain, Deputy Election Commissioner, and other officials of the Election Commission under Section 269, 270, and 304. Read with Election 120B of the Indian Penal Code 1860 in Khadda Police Station, Kolkata. In such a situation, the Election Commissioner sought an order from the court that a media can report only what forms a part of the judicial record. It means that media could not report all the details of court proceeding which occurs in a court, whether oral or otherwise. This issue was taken to the Honorable Supreme Court of India by its civil appeal number 1767 of 2021. Title of the case was the Chief Election Commissioner of India versus M.R. Vijay Bhaskar and others. This issue was decided by Dr. Dhananjay Y. Chandrachud. Honorable Judge, vide its judgment dated 6/5/2021, passed therein. The Honorable Supreme Court of India observed that oral remarks are not a part of the official judicial record and therefore the question of expunging them does not arise. It is right to say that a formal opinion of a judicial institution is reflected through its judgments and orders and not its oral observations during the hearing. Hence, in view of the above discussion, we find no substance in the prayer of the EC for restraining the media from reporting on court proceedings. The Honorable Apex Court further observed that this court stands as a staunch proponent of the freedom of the media to report court proceedings. This, we believe, is integral to the freedom of speech and expression of those who speak, of those who wish to hear and to be heard, and above all in holding the judiciary accountable to the values which justify its existence as a constitutional institution. This judgment plays very important role in keeping the freedom of media intact in reporting the court proceeding. Right of media to report court proceeding, sine qua non for a healthy democracy. The media would be having right to report what all transpires during a court proceeding. Though the opinion of court is always expressed through judicial orders, the reporting of media is merely considered as reporting of court proceeding. One should not put a mask on the mirror in order to hide scars on his face. Rather, remedial measure is required to be taken to cure the scar. Of course, media is the mirror in which errant behavior of system appears. timed is to correct to errant behavior rather than declaring the mirror errant. The Honorable Supreme Court of India further emphasized the need for judges to exercise caution in off-the-cuff remarks in open court, which may be susceptible to misinterpretation. This observation made in the said judgment also highlighted the need of honorable judges to exercise restraint while making any oral observation. Anyway, this judgment reiterates necessity of press freedom for a healthy democracy. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe the channel LEXCLIQ.